So one, yes, the meeting is being recorded and will be posted on our website. The Committee on Open Government's website has a section from its homepage. If you scroll down, you'll see a link to a section called Training Materials and Recordings. So you'll find a copy of this, a recording of this program there on our YouTube recording page. Second, this version of the PowerPoint that I'm using, I don't think I intend to post it because, to be perfectly honest, all it is I took the provisions of the statute, the new language of the statute, and I placed it, I placed each section on a PowerPoint slide so that we could go over each piece point by point. So the PowerPoint doesn't really have any additional valuable information than what you're going to be able to find in the statute in section 103A of the Open Meetings Law. So I don't believe I will post the PowerPoints on the website, but of course, if you're not aware already, I'm going to show you. One moment, please. I'm going to pull up Sorry, I was just taking a little bit longer than I had hoped for. I'm going to show you where you can find, I'll hide this little box here, get rid of it. If you go to right here, this is our home page. So as most of you know, you can find copies of the information law here. You can find copies of the Open Meetings Law here. On our home page, we tend to keep the most important information, the most recent information, updates to law and programs here. So we have a question and answer document right here. If you click on this Read More link, it'll bring you to our Q&A. So that's another guidance document that'll be available to you. Someone was just telling me that, but you can't see that. I thought it would switch over to sharing the screen, but someone is telling me that they can only see the PowerPoint. Well, I apologize. I don't know why it's not sharing the, but anyway, we'll go back to the PowerPoint. It tells me I'm sharing. Stop sharing. Yes, I want to stop sharing. Now I'm going to go back to hopefully now you'll be able to see what I was trying to show you from our home page. Right here is our section on the questions and answers regarding the recent amendments. So thank you for letting me know. Sometimes I can't. I'm glad that the Q&A is popping up because that's always helpful when people let me know that I've messed up the technology. All right, so what we're going to do now is I'm going to stop sharing that, and now I'm going to go back to sharing the PowerPoint. Okay, so as I said, the focus today will be on the recent amendments to the Open Meetings Law. We'll get a recording of this program if you want to refer friends and colleagues to it. Hopefully by mid next week, I'll be able to have it up on our website. That's my contact information if people have questions, my email address, our office telephone number. You don't just have to speak with me, of course. You can speak to any of the attorneys in the office. Anyone should be able to help you, and there's our website. The Open Meetings Law is codified in Article 7 of New York State Public Officers Law, Sections 100 through 111. But as I mentioned earlier, you can always find an up-to-date version of the statute on our website, as well as the Freedom of Information Law. So a little background here. Of course, as most of you probably that have logged on today are aware and know that we've had the Open Meetings Law has been in a bit of a state of flux for the past, 26 months, I would say. since the beginning of the declared disaster emergency in March of 2020, when Governor Cuomo issued an executive order declaring a state of emergency for the state of New York due to the pandemic. At that time, an executive order was issued suspending the in-person requirements of the open meetings law. That was in effect through June of 21. Then there was a short period of time from end of June 21 through the beginning of September of 2021, where the suspension was no longer there, and everyone was required to go back to the open meetings law as it had existed pre-COVID, pre-pandemic. In September of 2021, Governor Hochul signed Chapter 417 of the laws. Someone just asked if there's audio. Can people not hear me? If you can hear me, can someone just send me a note? Okay, so if the person that said that they can't hear me, the problem is probably on you may just need to turn your volume up, so thank you. Thank you for letting me know. So Chapter 417 essentially took the language of the executive order and put it into statute. And it authorized public bodies to meet and take such action authorized by law without permitting in-public, in-person access to the meetings, and authorized such meetings to be held remotely by conference call or similar service, provided that the public has the ability to view. Oh, people are so smart. Someone told me that I should really let that person know that it was since they can't hear me. See, I'm not as tech savvy as I hope to be sometimes. All right, get rid of that. So that was in effect until January of 21. At that point, Governor Hochul signed into law Chapter 1 of the laws of 2022, which slightly amended the Chapter 417, not significantly, but it amended it a little bit. And the difference was the expiration and repeal date. For Chapter 1 of the laws of 2021, the expiration and repeal date is contingent upon the expiration and repeal of the declared disaster emergency. So Chapter 1 will expire when the state's declared disaster emergency expires, and currently that brings us to June 14th, 2022. That was just recently extended again this past weekend. It had been in effect through May 15th, and now it's in effect through June 14th. Since the beginning, this was permissive. It allowed public bodies to have remote meetings, but did not require public bodies to have remote meetings. So then on April 9th, 2022, Governor Hochul signed Chapter 56 of the laws of 2022, and this was part of the New York State budget process. So it was a budget bill. It was included in the budget. Included in the budget bill was an amendment to the open meetings law to make permanent, and I use the term permanent loosely because it has a set expiration date of July 1st, 2024. The expanded use of video conferencing by public bodies to conduct open meetings under extraordinary circumstances. And that term is going to be very important as we go along, and you're going to get sick of me hearing me say the term extraordinary circumstances. And so it expands the use of video conferencing by public bodies to conduct open meetings under extraordinary circumstances, regardless of a declaration of state of emergency. I want to point out at this point, it's our understanding, based on our conversations with the governor's office and with the legislature, that the new law is not meant to change or curtail what has always been required of public bodies complying with the open meetings law. Public bodies may continue to operate now as they did before the onset of the pandemic in early 2020 when the in-person aspects of the open meetings law were first suspended. In other words, we believe that if a public body was permitted to do it before the pandemic, this law does not change that. As noted above, this law is intended to expand in extraordinary circumstances only the ability of public bodies to meet using remote access technology. Chapter 56 also gave us all a grace period. For 60 days after the effect of Chapter 56, which went into effect on April 9th, 2022, so the 60 days brings us to June 8th of 2022, public bodies are authorized to meet and take such action authorized by law without permitting in-public, in-person access to meetings, and authorizes such meetings to be held remotely by conference call or similar service, provided that the public has the ability to view or listen to such proceedings and that such meetings are recorded and later transcribed. And of course, if that language sounds familiar to you, because it's substantially the same as the language of Chapter 417 of the laws of 2021 and Chapter 1 of the laws of 2022. So this is where it gets slightly confusing, but I think the most important thing for everybody to just keep in mind is that public bodies at this moment, because of the extension of the declared disaster emergency, they continue to act as they have been acting in terms of remote meetings through June 14th. So Chapter 56 gave us that 60-day grace period through June 8th, but Chapter 1 is still in effect, and Chapter 1 is saying, nope, you can still do it through June 14th because the state of emergency is in effect through June 14th. And it's also possible, I have no idea because I find out when everybody else does, usually the day of the expiration, it's possible on June 14th of 2022 or slightly before then or slightly thereafter, we may get another extension of the declared disaster emergency. And if that occurs, say for example on June 14th we get another 1-month extension, which would bring us, I believe, to July 15th, I think, or excuse me, July 14th, probably because June has 30 days. It's possible we might get another month. We might get another month of Chapter 1 being in effect. It's possible we might get another 2 or 3 months. But at this point, what we want to keep an eye on is how long Chapter 1 is in effect. And right now, Chapter 1 is in effect through June 14th of 2022, and that's how long we are permitted to have remote meetings in the same way that we've been doing for the past 2+ years. So here's where I'll point out that the Committee on Open Government has prepared a series of questions and answers regarding the new video conferencing amendments, and those are available here. And I think if I click on it, it might not, you guys might not be able to see what I'm clicking on, but just so you know, it brings us to that question and answer that I showed you all at the beginning of the program. So here's where I'm going to start digging into basically each section of the law as we go along. But before I start, I want to point out that there are 2 ways to use video conferencing technology to conduct an open meeting. The first is the way that we always used to do it pre-pandemic, and that is where you would have multiple physical locations that are open to in-person public attendance. For example, the Committee on Open Government pre-pandemic would always have 3 physical locations. We have appointees to the Committee on Open Government that are located all over the state of New York, so to try to make their lives easier, we would open up Department of State offices. We would have a conference room open in Buffalo and in Albany and in New York City. And then each member could attend at the location that was closest to them, that made it easiest for them to attend the meeting. When we put out the notice of our meetings, we would tell the public that there was 3 physical locations. Here's the address for the 3 physical locations, and let them know that they were welcome to attend at any of those locations. We can still do that. That is, as I said at the beginning, we've been advised that if we were allowed to do it pre-pandemic, we are allowed to continue to do it. So if you have multiple physical locations that are open to the public, that are included in the notice as being open to the public, you can continue to do that in Section 103A. The new language is not going to apply. The second way to use video conferencing technology to conduct an open meeting is this new way that was included in the Chapter 56 amendment. And that allows a member of a public body to participate from a private location, a location that is not open to the public, through video conferencing under extraordinary circumstances. And as I just mentioned, if a public body is using the first, oh, sorry, I have a typo there. First type of video conferencing, not first time of video conferencing, and that is connecting multiple physical locations open to the public, the new Section 103A of the Open Meetings Law does not apply. Chapter 56 only applies to situations where a member is participating from a private location that is not open to the public. Section 103A, I'm going to start going through piece by piece, states that a public body may, in its discretion, so again, this is not an obligation on the part of a public body. If a public body would like to continue to have entirely in-person meetings without the use of any extraordinary circumstances video conferencing, it may. It is not required to adopt a resolution, local law, policy allowing for this type of extraordinary circumstances video conferencing. It is within the public body's discretion. So it may, in its discretion, use video conferencing to conduct its meetings pursuant to the requirements of this article, this Section 103A, provided that a minimum number of members are present to fulfill the public body's quorum requirements in the same physical location or locations where the public can attend. So what this means is that you need to have at least a quorum of the board present at locations that are open to the public. If one of the members of the public body is participating through the use of extraordinary circumstances video conferencing, that person does not count towards the quorum. If a quorum is met through other means, the person can participate and can vote, but they do not count towards a quorum. And from a practical perspective, what this is going to mean also is you can't have a public body with the majority of members are participating using extraordinary circumstances video conferencing. You have to have a majority. You have to have a quorum that are physically present at locations that are open to the public. One of the criteria that needs to be met in order to authorize this type of extraordinary circumstances video conferencing is that the governing board of a county, city, town, or village must adopt a local law. Or other types of public bodies, such as for our sake, the Committee on Open Government is going to have to adopt a resolution. The Senate and Assembly is going to have to adopt a joint resolution. And all of these entities, whether you're a governing board of a municipality, whether you're any other type of public body, if you want to authorize the use of extraordinary circumstances video conferencing, you're going to have a public hearing. We have been advised from, we consulted with the governor's office, and it was their understanding when they signed the bill that that was what the obligation was. All public bodies are going to have a public hearing prior to either passing the local law, which is sort of expected anyway because you need to have a public hearing to pass a law, adopt a local law. But even for non-governing bodies that are public bodies, they will have to have a public hearing prior to adopting the resolution. The larger public body can pass a local law or resolution for itself and all of its committees or subcommittees, or it can specify that each committee or subcommittee can make its own determination. There's a specific note relating to New York City community boards. So here the language of the statute talks about community boards in a city with a population of 1 million or more. Well, that's shorthand for New York City. So each community board in New York City shall make its own determination. And here I'll note too that it's our understanding that, for example, a county legislative body, so county legislature or a county board of supervisor can choose to make a decision for itself and for all of the public bodies hosted by the county, for example, or it can make a decision for itself and specify that each of the public bodies that are hosted by the county can make its own determination following the adoption of a resolution and public hearing. The law requires that the public body must establish written procedures governing member and public attendance consistent with this new Section 103A, and such written procedures shall be conspicuously posted on the public website of the public body. So once you've adopted those written procedures governing the use of extraordinary circumstances video conferencing, those procedures must be conspicuously posted on your website, on the public body's website. The law states that members of the public body must be physically present at any such meeting unless such member is unable to be physically present due to extraordinary circumstances, as set forth in the resolution and written procedures adopted pursuant to the Open Meetings Law. And those extraordinary circumstances can include disability, illness, caregiving responsibilities, or any other significant or unexpected factor or event which precludes the member's physical attendance at such meeting. It's going to be up to each public body to determine what they consider to be extraordinary circumstances. Except in the case of executive sessions, the public body shall ensure that members of the public can be heard, seen, and identified while the meeting is being conducted, including but not limited to any motions, proposals, resolutions, and any other matter formally discussed or voted upon. So what this means is while Chapter 1's been in effect, a member of a public body could participate via teleconference, for example, or they could have been on WebEx or Zoom with their cameras turned off. That's not going to be allowed anymore. All members of a public body are going to need to be heard, seen, and identified. So you're going to have your members are going to have cameras on at all times, and anytime they're speaking, of course, they need to have their audio on, but they should act as if they're in the room. They should be heard and seen just as if they were in the room with the members. There's an additional reference to identified. What this also means is all members of a public body, if you walk into the room where the meeting is being held, you should be able to identify who's speaking. And in our opinion, this doesn't apply just to the members that are participating via extraordinary circumstances video conferencing. It's going to apply to all members. So if you don't already, members of your public body should have placards that identify them by first and last name. And if you have a member that's participating via video conferencing, when they log on, they need to ensure that their screen shows their full first and last name. The law requires that the minutes of the meetings involving extraordinary circumstances video conferencing shall include which, if any, members participated remotely must be available as normally would be available to the public pursuant to Section 106 of the Open Meetings Law. So, for example, if you've got 10 members and 7 of them are physically present and 3 of them are using extraordinary circumstances video conferencing, you're going to need to identify which of the members were there physically present in the room that was open to the public and which were using the extraordinary circumstances video conferencing. If this type of extraordinary circumstances video conferencing is used to conduct a meeting, the public notice for the meeting shall inform the public that video conferencing will be used, where the public can view and or participate in such meeting, where required documents and records will be posted or available, and it must identify the physical location for the meeting where the public can attend. So in addition to the regular notice requirements, there's going to need to be a link to the public so that the public knows how they also can log on via video conferencing. It's also going to need to, that notice is going to need to include an indication where people can find the records that are scheduled to be discussed during an open meeting. That's a provision of the law that's been in effect for about 10 years. Section 103E talks about records scheduled to be discussed during an open meeting. It was recently amended in fall of 2021 to require that they be posted 24 hours, at least 24 hours before the meeting. So now Chapter 56 says the notice should include an indication where those records can be found. The law states that the public body shall provide that each meeting conducted using extraordinary circumstances video conferencing shall be recorded, and such recordings posted or linked on the public website of the public body within 5 business days following the meeting, and shall remain so available for a minimum of 5 years thereafter. And the recording shall be transcribed upon request. This is a small difference from the from the executive orders, Chapter 417 and Chapter 1, which said shall be later transcribed. Chapter 56 says the recording shall be transcribed upon request. If extraordinary circumstances video conferencing is used to conduct a meeting, the public body shall provide the opportunity for members of the public to view such meeting via video and to participate in proceedings via video conferencing in real time where public comment or participation is authorized, and shall ensure that video conferencing authorizes the same public participation or testimony as in-person participation or testimony. So in other words, if your public body has a time set aside for public comments, public participation, privilege of the floor, whatever they want to call it, and if they allow members of the public who present themselves in person to the physical location where the meeting is being held to participate in that public comment period, they have to allow members of the public who are participating, or excuse me, who are attending the meeting via video conferencing to have that same ability to make a public comment. Here, the law states that a local public body electing to utilize this extraordinary circumstances video conferencing to conduct its meetings must maintain an official website. It's not clear to me why they specified local body. They do define what a local public body is in Section 103A of the law. My feeling is likely it's because most state public bodies already have a website, so they didn't focus on state public bodies. But if a local public body does not have a website, it's not going to be able to comply with the requirements of posting its recordings to the website afterwards. So these two things go hand in hand. They're going to have a website if they want to do this. I have a blank page for some reason. The in-person participation requirements of Section 103A 2C shall not apply during a state disaster emergency declared by the governor or a local state of emergency proclaimed by the chief executive of a county, city, village, or town if the public body determines that the circumstances necessitating the emergency declaration would affect or impair the ability of the public body to hold an in-person meeting. So my understanding of what this means is if there is a state of emergency, while that state of emergency is in effect, you can hold your meetings as you're allowed to hold them right now. The language here is not very specific. It doesn't tell you what you are required to do. It just says that the in-person participation requirements shall not apply. I think in other words, you can go back to having these remote meetings without having to assert the extraordinary circumstances. This is a provision that applies to me, to us, the Committee on Open Government, but it may be of interest to people because as we move along, as public bodies start implementing these video conferencing the process by which they will be complying with the extraordinary circumstances video conferencing, if public bodies or members of the public see issues that are arising If they want to bring to our attention things that are working well, things that they feel like are not working well, the Committee on Open Government is going to be required to prepare and issue a report to the Governor and the Legislature concerning the application and implementation of this amendment, and also to make any further recommendations governing the use of video conferencing. So we need to do that no later than January 1st of 2024. So in the next year and a half, I would say that if people would like to provide feedback to the Committee on Open Government about how they think things are going, I think personally I would ask that people not bring their concerns to us right now, because we know we're aware that things are, seem confusing. We're aware that we're not quite sure how things are going to work out. What's going to be more important to us is how things actually work. We want to know how things are actually not going. We don't necessarily need to know the fears that you have about how it may turn out, because honestly we have those same concerns. We don't know how things are going to turn out. So telling us what your concerns are about how things might turn out is not going to be particularly helpful. Letting us know how things are actually working once things are up and running, that's going to be what's helpful to us. And the last provision of the statute states that open meetings of any public body that are broadcast or that use video conferencing shall use technology to permit access by members of the public with disabilities consistent with the 1990 Americans with Disability Act as amended in corresponding guidelines, and for the purposes of this section, disability shall have the meaning defined in New York State Executive Law, Section 292. And here I want to point out is that the Committee on Open Government are not ADA experts. We are not going to be able to provide guidance to you about whether something is or is not compliant with the Americans with Disabilities Act. So here, if you are a public body and want to make sure you're compliant, you're going to want to consult with somebody within your organization that has an expertise in that area. If you are a member of the public and you are concerned, you have concerns that your public bodies are not complying, our office is going to be able to weigh in on that. We're not going to be able to provide an opinion as to whether a public body is acting in compliance with the Americans with Disability Act. So of course, as always, anyone's welcome to contact our office by phone or by email with questions. Whether you're a government employee, members of the public, media representatives, etc. That's our phone number. That's our generic email account. So that goes to everybody in the office. Whoever is available can try to respond. So what I'm going to do now is I'm going to go to our chat function and open up questions and answers. Just a second. Someone asked me, will the COOB guidance on the new budget language be reposted to the website? I don't know what that means. We have questions and answer. We have a Q&A on the, where's that a beat? I don't know what that was. We have a Q&A on our website. So I don't know what that means. So if the person who asked that question wants to follow up, we do have the Q&A posted on our website. Someone asked, could the state's declared disaster emergency be extended again after June 14th? Yes, I think that's always a possibility, but I won't know until you find out. Someone said, is it possible to get a copy of the slides after the presentation? As I mentioned at the beginning of the presentation, I'm not going to be posting the slides to the website because essentially it's just the language of the statute. If you go to the language of the open meetings law, you can read section 103A of the law, and that's all the slides are. Someone says, I'm a new president of the board, where can I take a class on the open meetings law? We have recorded programs on our website that cover the open meetings law generally, and you can go to those YouTube videos. Someone asks, does heard mean unmuted at all times? I think heard means exactly sort of what the practical meaning is that anytime that someone is speaking, they need to be unmuted. If they would like to keep themselves muted to prevent feedback and things like that while they're not speaking, I don't really see any problem with that. But yes, of course, anytime the person is speaking, they must be unmuted. Is this requirement of heard, seen, identified, enforced now, or will be required only after this new law takes effect? So keep in mind this section 103A is only going to apply to situations in which you are using extraordinary circumstances video conferencing, and that's where this heard, seen, and identified comes from. In order to comply, in order to take advantage of this new provision of law, a local public body is going to need to either, the governing body is going to need to pass a local law, the public bodies are going to have to pass a resolution. And once they do that, part of the requirement is that anyone that's participating via that video conferencing has to be heard, seen, and identified when they're participating pursuant to section 103A. Right now, a board could be using video conferencing pursuant to chapter 1 of the laws of 2022. So technically, no, they don't need to be heard, seen, and identified. I mean, they need to be heard, but they don't need to be seen and identified right now. I think in terms of good government, my feeling is that they probably should be. Someone asked, will a recording of this presentation be shared? As I mentioned at the beginning, all the programs that I do are recorded and will be posted on our website. Someone asked, who's the final arbiter on this special circumstance for public body members who believe they can't be in person? That's not for us to say. That's going to be a determination that has to be made by each agency or public body. Someone asked, can you confirm that the body needs to define what the extraordinary circumstances will be that they find appropriate? Yes, that is correct. Someone asked, any thoughts on what ADA compliance means? What do municipalities have to do? To my friend who asked that, I wish I knew, but I don't. We are not experts on ADA compliance. The one thing that we do believe that public bodies are going to be required to do is probably have closed captioning, but honestly, that's just a guess on my part. I am not an expert on ADA compliance. Someone asked, are there examples of what can be considered an extraordinary circumstances? And I would just say what's already included in the statute are examples of what would be considered extraordinary circumstances: disability, illness, caregiving responsibilities. If a meeting is recorded and the link is provided, does it also have to be transcribed so long as the minutes are also provided? The law states that it must be transcribed upon request. Someone wants to know, they'll ask for the last slide of the email address. Our email address for our office, which is also on our contact us page, is coog@dos.ny.gov. I'm told that my VPN might expire soon, so if I disconnect, give me a second and I will reconnect as I'm trying to find where I can enter my new code before I disconnect, so I'll try to be prepared for that. Someone asked, isn't Chapter 1 tied to Executive Order 11? Yes, we already talked about that. Can participants be provided with a copy of the presentation? We discussed that. What notice procedure must be used for a public hearing for municipality that has to pass a resolution? I can only tell you that you must comply with the meeting notice requirements for under the open meetings law. In terms of specific hearing notices, you're going to need to consult with your municipal attorney or your public body's attorney to ensure that you're complying with any other laws or statutes that might be in place. Extraordinary circumstances only apply to voting members. Can ex officio members reconnect to my network? So can someone just send me a note in chat letting me know that they can hear me? Thank you, I appreciate it. All right, I'm just going to go back to try to find where we were. So the last question that I started to address was about ex officio members. I would only say that if they are a member of the public body, Section 103A is going to apply if they wish to participate via video conferencing under extraordinary circumstances, if they are considered to be a member of the public body. Next question is regarding Chapter 56. What is considered a public place or a public location under the law? It has to be a location that's open to the public, is essentially what the law requires. And the location also needs to comply with Section 103B and 103D, which states that the physical location that is open to the public has to be ADA compliant. It must be physically large enough to accommodate the size of the crowd that they anticipate wanting to attend. Someone says that their health consortium is a public body but has never held a public hearing. What are the requirements for alerting? I lost, sorry, I just lost. My computer's being very, very difficult right now. Our health consortium is a public body but has never had a public hearing. What are the requirements for alerting the public as to a hearing being held? That's a great question. Committee on Open Government has never had a public hearing either. Or if it was a very, very long time ago before my stint here. You're going to just need to consult with your counsel to see if there's any statutes that apply. If not, I would just ensure that the notice is provided pursuant. If there are no other statutes that apply, you're going to want to comply with the open meetings law in terms of notice. That's if there are no other statutes that apply. Someone said, I attend a meeting where some board members put up static photos. I mean, if it's just a photo and it's not an actual video of the individual, that's not going to be compliant. Once they're holding their meetings under Section 103A, it's going to have to be an active video. If they're having a meeting next week, they can probably continue to do what they're doing because under Chapter 1, they only need to be heard, only needs to be teleconferencing. They don't have to have a video element right now if they're participating under Chapter 1. It's Section 103A of the new amendment that requires that they be seen via video conference. Next question, do the members of the public also need to have extraordinary circumstances to video conference? Do they need to be seen, heard, and identified? The answer to that is no. So once you have video conferencing because one of your members is using video conferencing, then anyone in the public is going to have the right to attend via video conferencing. Once you allow one of your members to use extraordinary circumstances, any member of the public has the right to attend, and no, they don't need to be seen, heard, and identified. Can municipalities adopt local state of emergencies when the state emergency ends to continue to avoid complying with Section 103A? I don't know what the procedure is for declaring a local state of emergency. I think if the local municipality feels that there's a valid reason for declaring a local state of emergency, of course they can. If the sole purpose is trying to avoid complying with Section 103A, I think they may run into some legal challenges. I think any declaration of a local state of emergency, once the state-level state of emergency has expired, might be closely scrutinized, but it's not really my area of expertise. Someone asked about how does this law interact with advisory boards. The Open Meetings Law applies to public bodies subject to the Open Meetings Law. If you are a public body that is subject to the Open Meetings Law, then Section 103A is part of the Open Meetings Law and applies to that public body. I think the person who asked the question talks about, they use the term ARB. I don't know if that's Architectural Review Board, but it's my understanding that Architectural Review Boards are public bodies because they serve a statutory function. So under those circumstances, they're a public body and have to comply with all elements of the Open Meetings Law. Someone else asked about local bodies declaring a local state of emergency, which we just discussed. The extraordinary circumstance exception, does that have to be memorialized in any way or communicated to the public in our meeting notices other than stating that video conferencing will be used? The notice of the meeting is going to need to state that a member is participating via video conferencing under extraordinary circumstances, and the meeting minutes need to reflect that a person is participating via extraordinary circumstances video conferencing. I mean, they don't have to say extraordinary circumstances. It could say pursuant to Section 103A or something like that. But yeah, the notice has to state it and the minutes have to reflect it. If a meeting of a statewide body is set up in 3 sites and there's an emergency declaration in 1 site, does the exception for non-public setting apply only to that site rather than the entire body? I'm not sure that I understand the question. This might be something for the person to contact me directly. If you have 3 physical locations that are generally, under most circumstances, open to the public, and there's an emergency declaration in one of, like in, let's say we do the Buffalo, Albany, New York City, and Albany has a local state of emergency, the public body would need to determine, the language is about it would interfere with their ability to have a meeting. That's what they would have to find. And I'm not really sure how that would interfere, having a state of emergency in one location would interfere with their ability to have the meeting from in-person sites, but maybe that person can follow up with me if they have specific questions. I think everyone needs to remember is that the legislative intent here was to, having remote meetings is not supposed to be easy. I don't believe the legislature wanted to make it easy for public bodies to have remote meetings. They wanted to create a specific exception for, as they say, extraordinary circumstances. So public bodies should not be trying to use this provision, this 103A, as a mechanism for trying to avoid having in-person meetings. I think if this, if it ever appeared that a public body was trying to push the law beyond its intended limits, I mean, it's just exposing itself to legal challenges. I think that's what public bodies are going to need to keep in mind. I think they need to make sure that they're not trying to push the law beyond its intended limits. Currently, the governor's executive order has been extended June 14th. May a municipality continue to use an all video conference? Yep, we've already talked about this, how right now we have until June 14th. Must it be live video of the person, not just a video of them? Yes, it has to be a live video. Do we have to provide a sign language interpreter in order to be heard? I don't know. I don't know what that means. I mean, if you're asking about ADA compliance, again, I'm not an expert on ADA compliance. With regard to extraordinary circumstances, is it up to the individual boards to define extraordinary circumstances? Yes, it is. We have model resolutions that can be used. Yes, if you reach out to me directly, we can try to provide you with model resolutions and model policies. Someone asked me to repeat the precise relevant dates. Does Chapter 56 allow public bodies to immediately return to virtual meetings even after they've resumed in-person meetings or under? I don't understand this question. Right now, Chapter 1 of the laws of 2022, which expiration and repeal date is contingent upon the expiration and repeal of the state declared disaster emergency, is in effect through June 14th, 2022. That's the date I think that most people need to keep in mind right now, because at this point, until June 14th, 2022, public bodies can continue to hold remote meetings the way they've been holding remote meetings for the past 2+ years. So instead, we'll be holding additional trainings for those who are not able to make it today. I do trainings all the time, but I'm not going to do this exact program again, but it's recorded. So if you'd like to watch it, or if you want to share it with someone, it's going to end up getting posted on our website. Someone asked, can the law itself have the procedure included? Would posting of the law on the website suffice as those written rules? If we're talking about local laws, that's up to each individual governing body to determine whether the local law wants to include the procedures. The only reason I might recommend against that is that if you ever want to amend the local law, you're going to have to have another hearing. Whereas if you just want to amend procedures, that wouldn't be required. Does the public body have to specify in the resolution or a member? The resolution needs to identify what the public body considers to be an extraordinary circumstance. The member participating via video conference is going to need to give the, they're going to need to explain to whoever is in charge of making a determination why they need the exemption. They're going to have to say, I can't participate today because of, or at this next meeting because of this. And the person who's in charge of making the decision is going to have to look at it and say, yes, that fits within our definition of extraordinary circumstances, or no, it doesn't. The answer is no, it doesn't. The person's either going to have to appear in person or just skip the meeting. People have asked again about whether we'll be having you contact us. We may post sample resolutions and policies, but we have not yet. But if you reach out to me directly, I can try to get you something. Counties with an executive and legislature require the executive to hold a public hearing prior to signing it. Will the county legislature be required to hold a public hearing as well prior to voting on the local law? just follow the procedure for passing a local law. Just sort of skimming through things where we've already addressed the question. Someone says, do members attending via video conference before June 14th need to be identified as much in the minutes? Once you're taking advantage, before June 14th, if you are continuing to hold your meetings pursuant to Chapter 1 of the laws of 2022, that's the law you need to comply with. Chapter 56, which includes the new Section 103A, needs to be complied with if a public body wants to allow for extraordinary circumstances video conferencing. Sorry, just skimming through here. What is the date by which the county legislature has to create rules regarding the meeting requirements? I mean, if you want to have uninterrupted ability to allow for the use of video conferencing, I would recommend that you get it done before June 14th. If you're not as concerned with that and are willing to go back to in-person meetings, there really is no date by which you have to adopt the local law. You could but you can't use extraordinary circumstances video conferencing until you adopt the local law. Someone says a planned vacation is not considered extraordinary circumstances then. That's not up to me to decide. If the bulk of the members are disabled, is that enough to qualify the entire body to continue to meet by teleconference? As I mentioned at the beginning, you have to have a quorum of a public body physically present at the locations that are open to the public. You cannot have a quorum of a public body participating via video conferencing. Someone is asking what we believe is meant by transcript. It is our understanding that this does not require, for example, a court stenographer or a professional transcription service. If your WebEx program or Zoom program will prepare a transcript based on its artificial intelligence, based on its listening, I think that's sufficient. I know they're not always perfect. I know that sometimes there might be typos and distorted words, as this commenter mentions, but it's our belief that if your remote access platform will prepare a transcript for you, that's sufficient to comply with the law. Someone again asked about requirements for public hearings. You're going to need to look to your own local laws for those. If you're not an attorney, or if you want to consult with your municipal attorney about what the requirements for passing a local law is. If at the county level, the city, town, village level, there are certain requirements for passing a local law. That's what you're going to need to comply with. Here's where I get the point where everybody told me I went silent because my VPR disconnected. In-person requirement of 103A states that in-person requirements of paragraph C of subdivision 2 of this section shall not apply. Is this your interpretation that all other requirements? Yes. Yeah, I mean, the open meetings law is not suspended entirely under when there's a state of emergency, just the in-person requirement. In other words, you can go back to having remote meetings under those limited circumstances where there's a state of emergency. Someone asked whether a municipality, a public body, has to define what they consider to be extraordinary circumstances. Yeah, they need to define extraordinary circumstances. Let's see, everyone's telling me that I came back, so that's good. Someone asked about staff. Can staff attend virtually from their offices? In my belief is that Section 103A only applies to members of the public body. Do you want to allow your staff or your attorney, someone who's not a member of the public body, to attend virtually? I think that's at the public body's discretion or the agency's discretion. Someone asked me to clarify the quorum rules for remote participation. So yes, I can go over that again. You need to have a quorum of the public body physically present at locations that are open to the public. So what this might mean, for example, when you're dealing with a town board, you would need to have at least 3 members physically present at town hall, for example. And then you could have 1 or 2 members that are participating via extraordinary circumstances video conferencing, but they're not going to count towards the quorum. Because there's a quorum present at the town hall, those video conference members can participate and vote. They just, like if you only had 1 or 2 members at town hall, you're not going to be able to have a meeting because you don't have a quorum present at a physical location that's open to the public. Another example is the Committee on Open Government, where we have Albany, Buffalo, and New York City that are all open to the public. It's an 11-member body. If we have 3 in Buffalo, 3 in Albany, and 3 in New York City, there's a quorum of members participating from locations that are open to the public. Even though they're not all in the same physical location, they're attending from locations that are open to the public, so they are all count towards the quorum. Someone shared with me a useful ADA toolkit. It's ada.gov/PCA toolkit/Chapter 5 checklist. So if people are looking for help on that, they can go to the ADA, the United States ADA website. Do you have to have a board member remote in order for the public to participate remotely? Many communities are doing a hybrid model. I mean, if you're asking me whether from the members, from the public's perspective, or if you're asking me from the public bodies can always do more than what they're required to under the law. The public body wants to voluntarily offer a remote option to the public. Of course, they're welcome to continue to do that, but they're only going to be required to do it if they are taking advantage of the extraordinary circumstances video conferencing. Someone asked if a meeting is held in multiple physical locations connected by video conferencing, but all members are present in person, is there a requirement for members being seen, heard, and identified? It's a good question, and I think technically the answer is no, because the requirement of the statute only applies when you're using extraordinary circumstances video conferencing. Do I think it might be a good idea anyway? Yes, but I think from a technical perspective, the answer is no. If you have, like, for example, our Committee on Open Government, those people in Albany, Buffalo, and New York City, if they're all physically present in one of those locations, I don't think we have to have, like, name placards for them. Do I think that's something that we're going to start doing? Yes, just because we think now that it's a good idea, but no, I don't think it's statutorily required. Sorry, my computer keeps, like, backing up into the, it keeps reversing through my comments instead of staying where I want it to stay, so I need to keep finding where I left off. Can applicants or participants having business before a board be required to attend in person when 103A is being used, or are they considered part of the public? That's another excellent question. I think that's really, I do think under those terms, it's at the discretion of the board. I think you could allow them to participate via video conferencing, but I think you could also require that they be there in person. You know what, I misread because it was I had two questions close together. Can applicants or participants having business before board be required to attend in person when 103A is being used, or are they considered part of the public? In this circumstance, I believe that if you are allowing one of your members of the public body to participate via the use of extraordinary circumstances video conferencing, you probably need to allow an applicant to attend via video conferencing. That, to be honest, I'm not 100% certain on that. That's a good question that I'm not certain of, but I think you might be required to allow them to participate via video conferencing. But if a member has been exposed to COVID and cannot attend in person but feels fine, if there's a quorum present, can the decision to participate remotely? Can a member pivot to video that day? Here's where the issue is with pivoting at the last minute, is that you may not be able to provide appropriate notice. If you have enough time to provide notice, because you're going to need to create a a remote link that's available for that person, but also provide that information to the public. So it's going to depend on whether you can provide reasonable notice to the public that a member is going to be participating via extraordinary circumstances video conferencing and provide that link to the public. If you can't, then no, I don't think that person can. I mean, they can either, the best scenario is if they should be quarantined, then they should just skip the meeting. Can you have a video conferencing option for all meetings, even if trustees don't utilize it at all meetings? Of course you can. You can always provide more than what you're required to do under the law. If you want to give the public access via video conferencing for every meeting, that's great. Please clarify what notice is required if a local law is adopted. It's my understanding that 72 hours notice of attending via the hardship exemptions is not required. As a practical, I think this is what we just addressed, and we do have a Q&A on our website on, I think, on this subject. Essentially, I think you need to provide notice as soon as possible. If extraordinary circumstances video conferencing has been authorized and someone needs to take advantage of the extraordinary circumstances video conferencing after the 72 hours notice deadline has passed, I think you need to provide notice as soon as possible. And if you can't get that information out to the public, if you can't notify the public of the change, which would include a link so that the public can also attend via video conferencing, I don't think that person is going to be allowed to attend. If you can get notice out, let's say, a day before the meeting, then I think, yes, the person is going to be able to attend, but you need to be able to get notice to the public of the change. Is there a minimum number of persons who must be present for public body meetings? You have to have a quorum present. So a quorum is a majority of total membership. If it's a 5-member body if they're full count 5-member body, you need to have at least 3. Yes, we have model resolutions. If you reach out to me, we can get those to you. Is it necessary for members of the public to have access to the room in which the members of the public body are physically located for the members of the public body to count towards a quorum? Yes. The answer to that is yes. Following the expiration of the executive order declaring a state of emergency, if a public body was to hold a meeting and allow remote sites be open to the public, is it necessary to ever adopt a resolution and comply with Chapter 56? if there are multiple physical locations that are open to the public, then Section 103A does not apply. Does the member have to give personal medical information to justify? They need to give enough information to the person who's in charge of making decisions so that person knows whether extraordinary circumstances video conferencing is warranted. Executive Order 4 currently declares a state disaster emergency for healthcare staffing shortages. This is a question. It's about if a public body has healthcare workers on it, could be hold virtual meetings irrespective. I don't think the answer. I think the answer is no. The state of emergency that comes into play is right now is the one through Executive Order 11. It has to be a state declared disaster emergency for purposes of. I think the answer to that is no. There's one there that has to do with healthcare staffing shortages. I don't think that would be enough to allow to suspend the in-person requirement pursuant to Section 103A sub 3. Can a village board adopt a resolution that affects subordinate boards, or would that have to be done via local law? I think a village board can adopt a local law that applies to subordinate boards, or in the alternative, each individual subordinate board can pass a resolution. Is there specific language which must be used in public body meetings to enter into executive session? That's a whole nother topic. That's not really the focus of our section of our talk here today, and we have multiple advisory opinions on our website under the heading of executive session sufficiency of motion if someone is interested in looking into that. Does attendee/invitee of a meeting who is not a board member but included in meeting notice required to attend, allowed to attend via video conferencing? Section 103A only applies to members of the public body. What a public body wants to allow invited guests to do is within their discretion. In terms of other states of emergency going forward, no, it's not. They want to know if I can weigh in on what standard public bodies should use to determine if they can waive the requirements to be physically present. That's not my area of expertise. The law just states that if the public body determines that the state of emergency would interfere with their ability to hold their meeting, that's what the law says. Can a board exclude committees and subcommittees from video conferencing and allow it for regular meetings only? Public bodies can choose what they want 103A to apply to. That's within their discretion. What happens if the extraordinary circumstance occurs after the meeting is noticed? We've already talked about that. Can you use a recurring remote link and state in the notice that some members may participate remotely to cover that sick day scenario? If there's a recurring remote link, yeah, I mean, I think you want to provide notice that a member will be attending via video conferencing as quickly as you can. If your original notice did not include a statement that a member would be participating via video conferencing, you need to get out a new notice as quickly as possible. Someone asked what would be considered a reasonable notice to the public. That's up to the courts to decide. Do you have to state that a trustee is participating via video conferencing in the notice, or just that video conferencing is being used? You need to state that a member is participating through the use of video conferencing. Can you include in your notice the disclaimer that one or more members may participate from a remote location via video conferencing in order to ensure, yeah, I think, yes, I think you can do that. You just want to make sure that if a member is participating via video conferencing, once you know that that's the case, I think you want to get an updated notice up to the public, and you want to make sure that there's a link available to the public. I think I've hit all of the questions, and I know it's confusing. It's been a struggle to work through. There's been so many scenarios presented that we're trying to work through, and we're trying to address all of those. So if you look at the Q&A, hopefully some of them are addressed. As you move forward, if you find that things are coming up, again, keep us informed. Let us know what your concerns are. We have no ability to waive the requirements of the statute, but we are going to be required by law to report to the governor and the legislature, so it will be helpful to know what the practical concerns are in terms of compliance with these provisions. And I appreciate everyone joining with me today. As I said, I will try to get the recording posted and up on the website as quickly as possible for you to share with colleagues if they're interested. Hope everyone has a good day, and stay cool this weekend. I saw somewhere that's supposed to get up into the 90s, so stay cool, stay hydrated, and hope everybody has a lovely summer. Thank you.